Okay, good afternoon, everybody. Thank you for joining us today for our Power of Attorney 101, the Basics webinar. If you have any questions during the webinar, please use the Q&A function on your device as we will be answering questions during the presentation. It is my pleasure to introduce Ellen Makovsky as today's speaker. Ellen has been a respected member of the elder law community for over 2 decades. One of the highlights of her distinguished career has been serving as the chair of the New York State Power of Attorney Task Force on Powers of Attorney. The goal of the task force was to create a more user-friendly power of attorney. And in light of that goal, the task force drafted legislation that they are hopeful will be passed in the next legislative session. Without further ado, I present you Ellen Makovsky.
Introduction. Today, we're going to be talking about powers of attorney and the basics of the power of attorney. I'm going to be describing to you what a power of attorney is, the different types of power of attorney that are available, and why a power of attorney can be so useful to every person. So let's talk first about what a power of attorney is. A power of attorney is a document where you can appoint somebody or more than one person to make certain financial decisions for you, and you get to determine which powers you're going to give the agent that you appoint. There's a really big elder law connection with powers of attorney because one of the basic components of elder law is estate and disability planning. Everybody understands the need to make a will. Eventually, we're all going to need one, but not everyone is so concerned about disability because people are think, oh, and I've had many clients say to me, I just want to die in my sleep. I never want to need a home health care aide. I certainly never want to go to a nursing, and I'm just not going to do it. We're living in the age of COVID-19. We all see now that unexpected things really can happen to us. Nobody is going to be confined to their home for practically 3 months because of the pandemic. Things happen. And putting a power of attorney in place so that you have somebody to make decisions for you in regard to your finances, if you can't do it, is a really important part of everybody's plan. So let's talk a little bit more about powers of attorney. And what I'm going to be speaking about is the statutory New York form for a power of attorney. And I sent you, everyone who registered, a sample of the power of attorney document. Now, the power of attorney document is really a 2-part form. The first part of it is for what I would call everyday type of powers and powers that do not go in any way to making gifts or transfers of assets. The second part of the power of attorney is the gift rider, which needs to be executed at the same time as the first part of the power of attorney. Although they look like 2 separate forms, they are not, and you need the complete form in order to have a statutory power of attorney that complies with the New York State statute, even if you're not going to allow for gift giving. You just don't fill in the gift giving part of the form if that is not a power that you want to allow your agent to have. So what does the power of attorney do? It appoints an individual to make specific financial decisions for you. And you have to authorize each one of the powers that the agent is going to be allowed to have. Power of attorney only concerns surrogate financial decision-making. It has no power over allowing somebody to make medical decisions for you. And a few weeks ago, we did a webinar on healthcare proxies, which is the method in New York that you use to appoint somebody to make medical decisions for you. So if you didn't get to see that webinar, you can find it on our website, makovskylaw.com, and you can revisit the healthcare proxy webinar if that is of interest to you. Today, we're talking about financial decision-making, powers of attorney. So first, who are the players? We have the principal. That's each one of you. The person who creates the document and who determines what powers are in the document, and the person who chooses who the agent should be to make surrogate financial decisions for the principal. Then we have the agent. And under the power of attorney statute, you can appoint one person to be your agent. You can appoint more than one person to be your agent. And you can determine, if you've appointed more than one person to be your agent, whether the two agents have to act together or whether you will allow them to act individually or severally. The power of attorney form also allows you to name one or more successor agents, again, who can act together, or you can authorize them to act individually. You need to think really hard about who your agent should be. You need to choose somebody that you have implicit faith in, that they're going to only be acting in your best interest, that they're going to follow your directions, and you really, really have to trust the person that you name as your agent, because your agent is going to be able to direct your financial affairs, is going to be able to get into your bank account, is going to be able to access all of your financial records. So most times when I have a married couple who come into the office and they're trying to determine who the agent should be, typically it's a no-brainer, because a married couple will usually choose the agent spouse to spouse. Often they own most of their assets together anyway, and there's a certain amount of trust between a long married couple. Clients also choose one or more of their children to be agents, and you need to think carefully about which child, or whether or not you want to allow both children to be your agents under the power of attorney, or to be the successor agent to your power of attorney. There's another position for appointment under the power of attorney statute, and that's the monitor. And a monitor is defined in the statute as a person who can be given the power to oversee and approve the acts of the agent. In my office, I encourage my clients not to appoint a monitor, because they should be appointing their absolutely most trusted person to be the agent, and you don't want that agent to have to ask permission from somebody to move ahead with every financial act that the agent is going to do for you. So typically on the power of attorney form, we leave the appointment of a monitor blank.
Ellen, before you move on, we have a question from one of the participants, and they'd like to know, do you need a lawyer to prepare a power of attorney?
The power of attorney is a form, but yes, it is very different from the healthcare proxy. The power of attorney is a form where you have to use the exact language of the power of attorney as set forth in the statute for the power of attorney to be a valid document. You can't take anything out of the power of attorney in the statutory language, but you can add many, many modifications to the document in specific spots within the document. The attorney will craft modifications that will make various disability plans available to you because you have the powers to allow for that. And I'm going to talk about that a little bit later in our webinar. In addition, unlike the healthcare proxy, the signature of the principal and the signatures of the agents all need to be notarized. And if you're authorizing gifts to be made by the agent, you need to not only have a notarized gift writer, you also have to have witnesses who sign, swearing that they have seen the principal sign the document. This is a very complicated document, and I strongly suggest the use of an attorney in creating one. Okay, so let's go forward and let's talk about the different types of powers of attorney. And so initially, all powers of attorney were non-durable, meaning they didn't survive your incapacity and they lasted for only a limited time. Powers of attorney were envisioned for business type situations where you needed somebody to sign a contract for you. You wanted to buy a house and you couldn't be present at the contract signing or the closing of the house. And so you would authorize your attorney to sign on your behalf. That's where we got the term attorney in fact, because your attorney was authorized by you to sign for you so that the house could be purchased. Non-durable powers of attorney can be revoked by at any time, and at your death or your incapacity, they are no longer good. The type of powers of attorney we use in disability planning are called durable powers of attorney. And the sample form that I sent out earlier today is a durable power of attorney. And if you turn to page 2 of the sample that I gave you and you look at initial D in the middle of the page, that is the phrase that tells you that the power of attorney is durable. And it doesn't even say it's durable. It says, the power of attorney shall not be affected by my subsequent incapacity unless stated otherwise. So that's what makes a durable power of attorney. And a durable power of attorney is a lifetime document, which means once you sign the document, once your agent signs the document and it has been properly notarized, the agent has the power to act as long as you are alive. At your death, the power of attorney dies with you and your executor takes over. People create powers of attorney so that if they become incapacitated, somebody can act for them. Somebody can do estate and tax planning for them, and somebody can make a Medicaid application for them, or do what needs to be done to make them eligible for Medicaid without spending down all of their assets. And much Medicaid and estate planning can be accomplished by a properly drafted power of attorney. Clearly, a non-durable power of attorney won't work, because if you're incapacitated, which is the time this planning is needed, the non-durable power of attorney is no more in existence. So we all need durable powers of attorney. Let's talk a little bit about springing powers of attorney. A springing power of attorney is a document that comes into effect at some future time that is defined in the power of attorney document. So typically in doing a springing power of attorney, the springing event would be a written statement by one or more of your treating physicians or some third party. I always hesitate doing springing powers of attorney. I don't like to do them, and I haven't done one in years, because no matter what you make the power of attorney spring on, it is often very difficult to get the bank or the financial institution to believe that the principal has actually become incapacitated. Doctors do not like to write letters that say you lack capacity when they know as a result of that letter, your daughter is going to be able to get into your bank account and make withdrawals. And maybe the doctor will be held liable because you really didn't want that to happen. And banks want lots and lots of backup information in regard to whether the power of attorney has actually sprung into action. And often, when you need to use a power of attorney, you need to use it pretty much immediately. So I don't find springing powers of attorney that effective. And if you need to appoint an agent who you really, really trust. And why would you appoint somebody who you'll only allow to act when you no longer have the ability to know if they're doing the right thing or not, as opposed to appointing somebody while you have your full capacities around you, and if the person is not following your directions or doesn't act in your best interest, you can simply revoke the power of attorney. So I don't think springing powers of attorney are particularly useful. My preference is for what we call a presently exercisable power of attorney. And that's a sample that I gave you for today's webinar. And in a presently exercisable power of attorney, once you sign the document, once the agent signs the document, the agent can also act. It doesn't mean you can no longer act. It means someone else can also act with you. Of course, the requirement of the statute is that the agent must act according to your wishes and your directions and in your best interests. And when you find, or if you ever find, that this is not happening, you revoke the power of attorney. And it's easy to revoke a power of attorney. You give written notice to the agent, you give written notice to the successor agent, and you give written notice to every financial institution that you do business with that the power of attorney is, has been revoked, so that the financial institution doesn't rely on the document.
Ellen, I have another question from one of the attendees. Besides revoking the power of attorney, are you able to limit the tasks or jobs that your agent can do on your behalf?
Yes, in a power of attorney, you get to actually authorize every specific power that you're going to give the agent, and you can pick and choose among the powers that are in the statutory form. You don't have to authorize every power, and you can modify the power of attorney to only allow the agent to do those powers you think are appropriate for the agent to do.
Okay.
So in order to sign a power of attorney, you have to have a pretty high level of capacity. And the legal standard is the same capacity that is required to execute a contract. The principal has to really know what they're doing. They need to understand what their assets are. They need to understand what kind of financial things the agent will be required to do for them. And they need to be a fully functioning person. The attorney, in preparing the power of attorney and overseeing the execution of the document, is also looking to make sure that the individual signing the document has the requisite capacity to do so. In later years, if the principal has lost capacity and the power of attorney was challenged because someone alleges that the principal lacked capacity, the attorney who supervised the execution can always come back and certify that they believe that the principal had capacity when the document was signed. And this is a really important reason we need to think about doing powers of attorney now while we're totally functioning, because one never knows when you'll become, when and if you will become disabled. And if there is no capacity to sign a power of attorney at a later time because you waited too long, a guardianship proceeding may be necessary to get control of your assets and to put somebody in place to take care of your financial life. And guardianships are lengthy, expensive court proceedings, and sometimes they result in someone other than a family member or a friend being named your guardian. All good reasons for doing a power of attorney now when you are choosing what powers you want to give the agent and who that agent should be. Google can be very, very dangerous. People go and look up powers of attorney on search engines all the time. Powers of attorney are in New York State are very persnickety. You have to use the most recent power of attorney form, and you need to use the New York State form. And it has to be the form that became effective in September of 2010. And there are lots of forms that were done previous to 2010. And if you choose that one to fill in and to sign, you don't have a valid power of attorney. The New York State statute says you have to use the exact language of the statute in the form. You can't change a word or a comma. You can't take anything out of the document. You have to use a certain type size when you print it out. The parts that are bolded in the statute have to be bolded in the form. You can add language to the statute to add different powers than are in the statutory form, but they need to be inserted in very specific places in the statutory power of attorney. Modifications to statutory powers of attorney forms in New York are very, very useful. There's lots of other powers that you might want to be inserting into the document. And this is one of the reasons you want a knowledgeable attorney to prepare the power of attorney for you. Let's look at the statutory powers first. And these are the powers that your New York State legislator has put into the document, and you will see them listed on page 2 of the power of attorney that I've sent you. And again, you can pick and choose among these powers, or you can go down to the very bottom of the list and you can choose power P, which will authorize all of the powers in the statutory document. So first we have real estate transactions. This would allow your agent to buy, sell, mortgage any real property that you own. B allows the agent to deal with your chattel and goods. So this is basically the stuff you have in your house, your things, your car. C allows the agent to deal with your brokerage account or any bond share or shares of stock that you may own. D allows the agent to take care of your banking transactions. And for most people, this is the most used power in the power of attorney because it will allow your agent to write checks on your behalf and to pay your bills on a regular basis. E allows the agent to take care of any ongoing business you might be operating. F allows your agent to talk with your insurance broker about any life insurance you might have, about your health insurance, about your homeowner's insurance, about your health insurance. And often powers of attorney are used in insurance transactions. G allows the agent to take care and sign for any estate transactions that you might be involved in, such as receiving an inheritance from somebody else. H, claims in litigation, are for the situation where you walk out of your house and you step off the curb, but you forgot to look both ways. And all of a sudden, bam, that bus comes and mows you right down. But the bus doesn't kill you. You're still, you've survived the accident, and H allows the agent to bring a lawsuit on your behalf against the bus company without first having to proceed with a guardianship proceeding. I is a very limited gift-giving power, and it will allow the agent to make gifts not to exceed $500 in any 1 year in total. And that can be expanded by authorizing gifts on the gift rider that is attached to the back of the document. J allows the agent to pursue benefits from various government programs for you. K allows the agent to take care of healthcare billing and payment matters. L allows the agent to deal with your IRA, your 403B, your 401k, and any other type of retirement benefit you might be entitled to. M is the catch-all for all tax matters, as is N, all other matters. And P allows the agent the power to delegate the power in the document to somebody else. So I misspoke before. I said P was, you could initial P if you wanted to allow all the powers, but I really meant you can initial the agent to do all of the powers enumerated in letters A through P. So after the statutory power of attorney form, attached to the back of it is what's known as the gift rider. And at first glance, it actually looks like the first page of the initial document, but it is not. It authorizes gifts or transfers of assets. And by what the statute defines as transfers of assets or changing beneficiaries on accounts, or changing the owner of the account, or adding a joint owner to an account. Those are all examples of transfers of assets under the power of attorney statute. The gift rider has to be executed or signed at the same time that the first section of the power of attorney is signed and notarized. And it has to be witnessed by two witnesses that you signed the gift rider, and that's done contemporaneously with your signature. The gift rider has a portion that allows you to authorize the agent to make gifts to themselves. So if you're doing estate planning using the gift rider to try to save some money on estate taxes, or you're doing Medicaid planning with the gift rider, you pretty much usually want to authorize the agent to make gifts to themselves, because you don't want the agent making gifts to me or gifts to Deidre. The agent is usually a family member, and that's a logical place for gifts to be made. And the New York State statute says, if the agent is going to be making gifts to themselves, you have to give that agent permission for that self-dealing. The gift rider in the statutory part of the form will allow you to authorize your agent to make $15,000 tax-free gifts annually to various family members. There is a modification section to the gift rider, and you can expand on those powers in regard to gifts and transfers of assets to enlarge the gift-giving power. And this is particularly useful in Medicaid planning or estate tax planning.
Ellen, we have a question from one of the attendees. Is the statutory form sufficient, or do banks also require their own individual forms?
Every bank has its own individual form, but they are required by law to honor the statutory, New York State statutory power of attorney. When you sign a bank power of attorney, it's only good for that account in the bank. And it's not going to allow for modifications that will allow you to make yourself eligible for Medicaid, or do estate planning, or to do many of the other things that the statutory power of attorney allows for.
Okay.
It doesn't hurt to sign the bank power of attorney, but it is in no way a sufficient plan. It's very important to have those modifications within your document. You need to add into the statutory powers that take care of day-to-day issues. For example, and I have many day-to-day issues in the power of attorney that I prepare for clients, but you might think about powers like the ability to hire and fire attorneys, accountants, home health care aides, social workers, people who are going to assist you, or people who are going to assist the agent in their day-to-day duties. You might want to include a power, a simple power to change your mailing address. If your agent is going to start taking over your bill paying and making sure that you don't default on any bills that come to the door, the agent's not going to want to have to take a half-hour trip a couple of times a week to empty out your mailbox and get your mail to make sure that all the bills are going to be taken care of. And a power of attorney will make sure that the agent can authorize a change of address. So those are examples of day-to-day issues that are not included in the statutory power of attorney, but can be added in the modification section. The power of attorney should include powers to take care of tax and estate planning issues. So, for example, it should give the agent the authority to sign the different types of forms that the federal government, the state government, and the county government require in regard to allowing your agent to sign your tax returns. The power of attorney should allow the agent to make gifts to eliminate any New York State estate tax that you might owe at your death. The power of attorney should include lots of powers to take care of Medicaid planning. And there are many powers in these categories that should be included in the modification section of your power of attorney. In order to draft a power of attorney, which is useful if you ever require long-term care, you really, the person who is drafting the document needs to have a very full understanding of the current Medicaid planning techniques. And I'm only going to touch on this very briefly because we will do another webinar on Medicaid eligibility in the future. But just to understand it from the point of view of the importance of powers of attorney, let me say that Medicaid is an entitlement program. It's different from Medicare. You have to have very little in assets or resources and very little in income in order to be eligible for the program. In fact, you can have no more than $15,750 in 2020 in order to be eligible for Medicaid in New York State. There are certain assets that are exempt assets that are listed here, and we're not going to go into those in much detail. I suspect most of you have more than $15,750 in assets currently. So how do you become eligible for Medicaid? Well, there are two ways to become eligible for Medicaid. You either spend down your money, you spend on your health care, you spend, but no more than $15,750 in assets, you're eligible for Medicaid. Or you can do what most people do when they come to visit an elder law attorney. They try to figure out how they can make transfers of assets so that they can become eligible for Medicaid without spending everything down. So let's take a look at the power of attorney and how it plays into that. So if you're going to go forward with the spend down of your excess resources, the power of attorney statutory form does allow the agent to engage in banking transactions. So this means that, yes, the agent will be able to take out your checkbook, will be able to pay the home health care aid, will be able to pay for anything else you need to support yourself in the house, and will be able, if you require it, will be able to pay the monthly nursing home bill by signing your checks as agent under the power of attorney. The statutory short form power of attorney allows the agent to deal with your stock and bond portfolio. So yes, your agent will be able to trade stocks and bonds, and will also be able to liquidate the portfolio as you need to draw down on those monies to pay for your care. So the power of attorney in the statutory form will allow for that. The power of attorney, however, the statutory form only includes a limited ability to make gifts. The first part of the form will allow a total of $500 to be gifted out. And the gift writer on the form allows for $15,000 annually to various family members. This is not going to, it will take a long time to spend down the money using the power of attorney, and there will be nothing left to support you at home and keep the house going while you are receiving Medicaid benefits at home. So that's one way the power of attorney can be used in a Medicaid eligibility plan. The power to make unlimited gifts is not on the power of attorney form. The power to create Medicaid asset protection trusts, which we use to shield assets, is not on the power of attorney form. The power to join and fund pooled trusts, which is a way we protect income for those who are receiving Medicaid at home, is not on the power of attorney form. The power to engage in other current eligibility techniques is not on the power of attorney form. So the form itself has to include modifications to provide the power to implement the plan to make you eligible if you are looking to become eligible via transfers of your assets. And we do this by modifying the power of attorney form to allow for an expanded gift-giving power. So when we are looking to possibly sometime in the future make gifts, we need to include the power on the gift writer to make unlimited gifts to trusted individuals or to a trust. So many times married couples will come in and they'll say, well, I don't need this. What would I need this for? My spouse and I own every single thing jointly. Well, that actually won't work, because if you become incapacitated and we want to make a plan for your house and we want to transfer the house and you lack capacity and you own that house jointly with your wife or with your husband, they can't sign the deed for you transferring the house from sick spouse to well spouse unless there is a power of attorney that authorizes the agent with that power. So we need the power to make unlimited gifts in order to become eligible for Medicaid without spending everything down. We need the power in the gift writer to create, amend, and terminate trusts. We need the power in the power of attorney to join pooled trusts to preserve income in a Medicaid situation at home. We need the power in the document to change the beneficiaries of various accounts or the owners of accounts, be they joint accounts or individual accounts. And we need the power to permit self-dealing, meaning allowing the agent, allowing the spouse, allowing the child to make gifts to themselves and to others. Powers of attorney need to be very carefully crafted. The power of attorney is the most valuable tool anyone can have in creating a plan for disability. The document needs to be drafted to suit your individual needs. Powers of attorney are the best tool you can have to make sure that you can preserve your assets for yourself and your family. Powers of attorney allow you to avoid guardianship proceedings. They allow for very significant tax and estate planning, and they will, if properly drafted, provide for Medicaid eligibility without spending down all of the assets. Today is the day you should begin to develop your plan. If you would like to talk to Deidre or I, give the office a call, and we would be happy to answer any further questions you have on powers of attorney.
And like Ellen mentioned before, if you'd like to view this webinar or one of our previously recorded webinars, they are available on our website at makovskylaw.com, or you can reach out to the office and we can provide you with the information.
Thank you very much. And we look forward to producing more webinars.
Thank you.